in the name of family law.
We are welcoming Kent Wood to the show. Kent is a family law attorney. He is a managing partner and the owner of Wood & Associates with offices in Battle Creek and Lansing. And today we're going to talk about the new discovery rules that started right before the pandemic in March 2020 and how that is helping families save money and helping the attorneys present better cases for their divorce clients. Kent?
Oh, thank you, Lisa. The discovery rule we're talking about has to do with divorces, and it has to do with division of property. And prior to this rule, you had to ask for questions, interrogatories, requests to produce, where we say, answer these questions and give me these things. You had to rely on the other side to do that. And it created a lot of stress. It created a lot of expense. So
stress for the spouse?
Yes.
Or for the attorneys?
Stress for spouse. And the attorneys.
Both.
When a marriage falls apart, there's a true breakdown, and it could be about finances. But when a marriage is building, there's a division of roles. Some people will take care of the home, and some people take care of the money. A lot of times when someone's taking care of the money, the other person doesn't really know what's there. So we have to ask the other side in the divorce to become an adversary. They're not going to give that information up. And it can become very expensive trying to get the information because the assets have to be divided in Michigan equitably.
So you mentioned property division, but I think the financial discovery information also relates to child support and spousal support too, right?
Right, because income is a major part of determining what child support is. It's also part of the factors considered in spousal support.
So can you tell us an example of how it worked for one of your clients before the new rules went into effect?
Yes, so one client, she must have spent somewhere between $3,000 and $4,000 just to get some information. They were married
from her soon-to-be ex-spouse.
Soon-to-be ex-husband. During the divorce process, they'd been married 40-some years. They were married young. She thought that there was about $50,000 in the bank account and about $50,000 equity in the home. When we did the discovery, he didn't want to give the answers. We actually had this do what's called a motion to compel, and asking the court again. He didn't do what he was supposed to do under the rules to do it again, and it cost more money to do that. And he eventually did, and we discovered there was close to about $750,000 in assets. So she was entitled to roughly half of that, or some division of that was more equal or equitable. And that was a big difference and helpful for her. But it did cost her an additional $3,000, $4,000 just to get that.
It was a lot more effort on your part. And that probably applies even more so when one of the spouses is self-employed or owns their own business, right?
Oh yes, it's very hard to get a valuation on businesses at times, especially if they're newer but seem to be growing in a growth state.
So do the court rules the new court rules make it easier to obtain this information?
Right. Now the court passed a rule in the beginning of COVID time, January 2020. We've actually seen it more enforced in the last 6-8 months in terms of how the judges are going to implement this rule. But the rule requires within 28 days of filing a complaint for divorce, you have to provide all the financial information. It's vehicles, bank accounts, debts, the whole financial picture and asset picture that you have to disclose. The other side, when they answer, has to as well. And that's a big part of the initial interrogatories, and it saves a ton of time and money.
So I'm guessing, knowing that this is going to be happening very early in the case, that when a new client comes to your office, you're probably asking them to start gathering that information. Here's a list of everything we're going to need from you. Start gathering it now, because we know it's going to take a little bit of time, and we know it's going to be very stressful for you as well. As you're dealing with the breakdown of a marriage, and you're also having to dig through papers and whatnot.
Yes, so the form requires all this disclosure of all this information, and we provided a list to clients to say, get us all this information. There's a lot of what I call fast and slow periods in a divorce. There's a lot of stuff in the beginning, and then there's a dull time, and then there's another stuff and another dull time. It gives somebody something to do. It's a very stressful time anyway. Here's a direction. Work on this, focus on this. Kind of actually started to help clients kind of calm the stress a little bit, because they have something to do to move forward in a difficult time. I also have clients, in terms of keeping track of things, it's personal property. I advise them all, go into each room, take a picture of each wall, open each closet, take a picture inside the closet, same with the garage and any outbuildings, just so we have an idea of where things are, because once the family separates, things start to disappear.
So under the old rules, if the person didn't comply, with the discovery request. You would have to file a motion to compel, you have a hearing, you go to court, then a judge orders them to produce it, and then they have time to produce it. And then if they don't produce it, then you do another motion. So is the process different now?
Well, the process is they're supposed to disclose it on the front end. And if they don't, we can go right to the kind of a motion to compel to at least answer the disclosure. It also creates they can't do any further discovery either unless they complete the form.
Oh.
So it kind of limits their ability
They can't get information from your side of the case because they haven't followed the court rules?
Right. And same for our clients. So we make sure they're in compliance so they can get more information. Courts have been deciding not to help you get more information if you haven't disclosed, fully. There's still potential for motions to compel. People, aren't honest all the time, and they may leave some things out.
Well, that's the question I have. What happens if you find out later in the case that they hid assets, or they had a bank account that they conveniently forgot to tell you about? What happens at that point?
Well, we actually had this particular case after this order was in effect, and we had this client that didn't know what all the assets were. We did the disclosures. We did some additional discovery after the disclosures, and through that we found some weird transactions in a bank account, and we found out the husband had a PayPal account, an online account somewhere, where he was wholesaling alcohol. He had $300,000 in this account that was just there. Now, the bad thing that happened for him is that he couldn't dispute what that was. He had to treat it all as a marital asset. He couldn't say some of that was a business thing or anything. That was kind of the punishment there. But there wasn't a clear what was going to be wrong if he violated that thing. That still hasn't really come to fruition yet in terms of the enforcement of this rule.
So I've heard of cases where one possible penalty a judge could impose on the person who hid assets is to use the term disgorge. The judge will treat everything in that account as belonging to the other side.
Oh.
I mean, it's a rare remedy, but it's something that, be warned. There's consequences to you trying to play games, right? And you mentioned the PayPal account. That's really interesting because I think a lot of times people have Cash App accounts or Venmo accounts, PayPal accounts, and a lot of times those accounts are building up money separately, and maybe you honestly you forget about it. Not $300,000, so you're not going to forget about $300,000, but you might have a smaller amount in an account. You got to remember all of those accounts, right? I mean, it's got to be complete, thorough, and all of that.
Right. I think it's the intention, right? If you didn't intentionally forget something, like you wouldn't forget something like that. But the problem is it's so much easier to hide an electronic account because there's no statement that comes in the mail. It just comes to whatever email the person directed it to. And it's either, people have several emails these days.
Great. Well, that was very interesting, Kent, and we hope we have some good relief for clients because they have the information they need.
All right. Thank you.
In the Name of Family Law is brought to you by Wood & Associates, PLLC.